Ocala's information station, 1370 WOCA.
Ocala.
All right, 25 minutes before 11 o'clock. Beautiful Wednesday morning, and John Fuller is in the studio. Today's Wednesday, May 29th, 2013. If that's the same date it is in your world, then you're listening to a live show, and you are invited to call John Fuller. He, of course, is an attorney here in Ocala at the law firm of Fuller and Fuller, and he comes into WOCA's studios to answer your questions about your legal predicaments. Sometimes he expands it beyond to some of the legal stories that are in the news, but the primary reason is to have your questions answered about your circumstances. It's a scary thing when you get a letter from a lawyer or a letter from somebody who requires the attention of a lawyer, and that's John's job, and does it every day. And let me turn around, and his wife, by the way, is also an attorney, Janet Fuller. Good morning. How you doing?
Good morning, Larry. It's good to be back with you live. We were out of town for a little over a week, so we're nice to be back. We've been having some real pretty spring weather, summer weather maybe, and we're glad that we have a chance to talk to our listeners. If they have legal issues that we can discuss in general terms, it's always a pleasure to hear from them. We do practice, the firm of Fuller and Fuller. My wife Janet and partner practices in the area of Social Security disability, and I do civil, business, commercial litigation, personal injury, accident cases, civil cases, and limited specialized area of substantial major family law cases. And if something comes into those areas of the law that we can help you with a specific legal problem, you can call us at our office. The office number is 352-547-4292. Hope you had a good Memorial Day. I hear you did your special show.
We did our Memorial Day special. Yes, it's a kind of a tradition with Robin and myself. So where did you go? Can we pick your brain?
Well, we had a lot of family in town,
Okay.
and we were over at Crystal River and around with various extended members of family. It was a very good time, and we didn't have. We tried to take it easy and enjoy the time to be together, and it was nice. Coming back is a little overwhelming. I walked into the office this morning, and when you're gone, the problems keep piling up. So we are triaging and working our way diligently through those issues that have emerged. So it's been a hectic morning, but I'm glad I got a chance to come down here. The legislature, I think, is pretty well wound down, and I see where it did pass an anti-texting law, which I think is a good thing. There have been some very tragic accidents occurred, and I think we all, from time to time, are guilty of having done that. And it's probably a very good law. I think Florida, I read today, was the 40th state to adopt some law like that.
Yeah.
And I think the legislature probably did a good job by making it a secondary offense, because it's it would be very problematic for law enforcement to make that a primary offense to stop you with. And one of the things that was hotly debated, and it raised an interesting question, is that when they were trying to make it a primary offense, in other words, they could stop you solely for texting rather than having to have stopped you for failing to stop at a stop sign and then noticed at the same time you were texting as you went through the stop sign. They had some language or amendments that were being debated that they would allow law enforcement to have unfettered access to all your cell phone records as a method of proving if you were texting at a particular time. That raised some very, very interesting rights to privacy questions, and I think overreaching. Fortunately, they took that out of the law. I think the cooler heads who were looking at the law realized that would probably render the law unconstitutional, and so the way they have it, I think, is the way it should be. So hopefully it will help cut down. Another interesting thing that has been bandied about is that the National Highway Transportation Safety Commission or something, it's just a bureaucratic agency. It's not a legislative branch. It's not a law enforcement branch. Came out with a statement that DUI ought to be the unlawful blood alcohol level ought to be reduced from a .08 to a .05 blood alcohol concentration. That, I think, is rather problematic. Just before I started practicing law, the DUI law said that it was unlawful to drive with a blood alcohol level of .15. Then, several years after I started practicing law, the legislature reduced it to a .10, and then after that to a .08. And now they want to reduce it to a .05.
Huh.
And I wonder where the pendulum stops. I mean, it is not a crime to imbibe an alcoholic beverage and operate a motor vehicle. What they're trying to prevent is operating a motor vehicle with impaired faculties,
right,
so that you're not able to operate it in a reasonably prudent and safe manner. There's a lot of debate on when impairment starts and when meaningful impairment starts. And the accidents that I've seen, both in civil cases and in criminal cases, that involved unlawful blood alcohol levels, you didn't see people getting into serious accidents with a .05 or a .06. It was much higher.
Really?
And I know they may have some statistics, but for the population at large, I think, people who run restaurants, who sell wine with dinner, someone literally could have a glass of wine and a champagne toast at a wedding reception, and if they were a person of very light body weight, could theoretically get very close to a .05. And so I think that creates some real issues. Another thing that most people don't know about is that we already have a law on the books that says that if you have a blood alcohol level between .05 and .08, they can't arrest you for an unlawful blood alcohol content, but they can arrest you for driving while under the influence to the extent that your normal faculties are impaired.
Oh, really?
And the evidence of blood alcohol between .05 and .08 may be considered by the jury and given whatever weight and sufficiency that it deems appropriate. Because a 230-pound man who goes home and regularly has a cocktail in the evening is probably not going to have the effect upon his mental faculties with having a .05 or a .06 or a .07 as, say, a 90-pound person who rarely, if ever, has any alcoholic beverage at all. So, like so many things, we don't necessarily need another law on the books. What we have is a system that gives law enforcement the flexibility. And if someone is operating a motor vehicle in a manner that gives probable cause that they're impaired, then they have a tool there to use. But it doesn't get to the absolutes that are so difficult with the law to deal with sometimes.
First of all, I want to make sure the listeners know that the calls are invited. If you would like to call John Fuller right now, the number is the WOCA Climate Control Source Hotline, 622-WOCA. And if I could interject a question about the new no texting while driving thing. The article that I read said that the law allows for talk-to-text messaging. So you can talk and text if you have that kind of a device. Then it says that if you are in an accident, the police can look at your records to see if you were texting and driving, and if that contributed to the accident, or may have. Okay. And then it says, and the third part that is applicable to this question is that all phone companies don't have the technology to discern between whether you texted by talking or simply texted.
Right.
So how are they going to deal with that?
Well, that was the point that I was making. I actually thought that the final draft of the bill had omitted some of that language. I know the original section where it was if you wanted to get it to prove the prima facie or in the first instance case, they could get the records. That was deleted. These other things, I think, create real issues concerning right to privacy and due process. But
if I'm talking and texting, then I'm not distracting my eyes from the road. I can talk, and my little machine will text to whoever I'm sending a text to.
Right, and I mean, would society tolerate a law that you couldn't talk to the passenger in your car
yeah, right.
Because the fact of carrying on a conversation distracted you from the unlimited focus of operating a motor vehicle? Of course not. I think that's taking it to an absurdity.
I'm just curious, from an attorney's point of view, how would you defend the person who says, yes, I was texting, but I have a talk to text, but my phone company only registers it as a text? Because the phone company doesn't know.
I think one could suppress those records if they did not have any probity value that would establish that you were texting. I've not read that portion of the law, but assuming that there was not the technology to discern the difference, I think you would have a very good grounds to suppress all of those records under a section of our evidence code, section 403, says that if the prejudicial effect of evidence is so inflammatory or so outrageous that it would outweigh any probative effect. So if they have some record that shows that you were, quote, communicating on your phone, but cannot discern whether you were doing it with a lawful talk-to-text or a actual hands-on texting method, and that does not address the probative aspect of that question, then I think the whole thing should be suppressed, because it would be prejudicial that a jury would then be left without any real probative evidence, but just a rank speculation, and that would, I think, potentially deny due process of law.
And you do have a phone call. Good morning. You're on the air with John Fuller.
Good morning.
Good morning. I have a question about a recent news item, and although it's slightly political, I'm going to frame my question in a way that will take away any of the political overtones, because I know you don't like to get political, Mr. Fuller.
Thank you.
The item was that the Public Defender's Office is going to start, as I understand it, they're going to start assigning priorities to certain cases, and cases they think are unimportant. Those accused persons are not going to be assigned a public defender. And to me, that seems blatantly unconstitutional. And my question for you, and I know that the judges and prosecutors and the state attorney in Marion County are all outstanding, but couldn't the state attorney use, I guess what you'd call it, as prosecutorial discretion to eliminate some of these more frivolous or unimportant cases so they wouldn't have to go to trial in the first place, and therefore the public defender's office could concentrate on the cases that are important and that the people do need representation? And I know that's a complicated question, but I'm just going to hang up and listen on the radio. Thank you.
Thank you. That's a very good question and raises a variety of very important issues. Some of them are policy issues as much as legal issues, but your point is well taken. The state attorneys throughout the different circuits of the state of Florida are probably the most powerful elected public officials in the state. They have the practically unlimited power to make the first decision on whether or not a citizen who has been arrested is charged with a crime or is not charged with a crime. So yes, they can, and they do, in fact, when they look at a case, if they find that after they review the evidence that that they do not believe that they can prove the elements of guilt beyond a reasonable doubt, then they dismiss those cases. It's called nolle proseque, or nol pros those cases. And all prosecutors take an oath to uphold the law, and that means not to prosecute cases that they don't have a good faith belief that they can secure a conviction on. And so that does happen. Should it happen more? That's a debatable question, and people can have strong feelings both ways. The system works when you have good people in it. There are also a variety of deferred prosecution type procedures, such as a pretrial intervention program, a deferred prosecution program. I know that in the 8th Judicial Circuit in Alachua County, the state attorney up there generally has broader criteria that allow more cases to be diverted from the criminal law docket into these alternative programs than we have locally. That's a decision that is in the discretion of each prosecuting attorney. Should that be more standardized? That, again, is a good policy, political question. But, of course, each elected state attorney is a constitutional official and has the discretion on how he or she manages and conducts the office, the policies and procedures and methods of prosecuting cases or not prosecuting cases in their office. Also, I'm not familiar exactly with the terms of the law that the gentleman mentioned about the public defender. We still have a requirement that an indigent person be appointed a public defender. There have been some cases that I read about where the courts have held that the public defender should not be appointed any more cases because they had such a heavy workload that they were unable to provide effective assistance of counsel as required by our Bill of Rights. You don't only have a right to a lawyer, but you have a right to effective assistance of lawyer. And if the lawyer appointed to you is already appointed to 200 or 300 cases, clearly it's going to affect the ability to be effective and to have the resources. The answer, in my opinion, like so many things, is that not to change the rights that accused citizens enjoy under the Constitution, as confirmed by our U.S. Supreme Court in Gideon versus Wainwright, which we talked about at length last year because it was the 50th anniversary of the Gideon case. But the bottom line really is in how we budget to do these things and what offenses would be appropriate for alternative resolution, such as pretrial intervention or deferred prosecution, that would take those cases out of the trial docket and allow the public defender and the prosecutor too, for that matter, to focus on the more serious offenses. The other thing is we need more money in our criminal justice system. We need to hire more people. We need to pay them better. That's true. That starts at the very basic level of law enforcement. We ask law enforcement to take extraordinary risks and work difficult hours and deal with difficult issues. And we have some real budgetary issues going on there that need to be addressed. And it's like everything else. The economy has not been good. The tax base has been down. Tax dollars have dried up, and it's affected our governmental services.
The subject of the Supreme Court, of the Florida Supreme Court, deciding that public defenders could reject some cases was something we talked about the other day. And one of the suggestions of a way to reduce the workload of the public defender was to have a more libertarian view of some of these laws that put people in the place where they need a public defender, like marijuana cases and things like that. What are your thoughts on?
Well, it's amazing to me, and I don't have the statistics, but the number of laws that have been enacted that are technically on the books that would be something that would require prosecution a number of those laws didn't even exist 20 years ago. It's easy for the legislature to pass a law and say, this is a criminal offense, now go arrest and prosecute people for things that were not offenses 20 years ago, and not fund it. And I think that there needs to be, if you're going to make these things criminal, and I don't know. There's a lot of differing views on the criminalization or decriminalization of things like marijuana. I don't really have an opinion that I feel strongly enough to get into in a public forum about. But I do think that just there's an awful lot of people that do not benefit from just being put in jail, and that our money, our tax dollar, would be well spent in programs that help people. There's a difference between, in my mind and in my experience, between someone who is a hardened criminal who consistently robs, as opposed to somebody who's hungry and his family's hungry and he's arrested for stealing food to feed his family. Somehow there seems to be a distinction there.
And you have a phone call. Good morning. You're on the air with John Fuller.
Hello?
I'd just like to... Hi, John.
Good morning.
Good morning, sir. I'd like to get your opinion, sir, on the... not necessarily for right here in Marion County, but just the overall concept. If you could address the privatization, the corporatization of jails, and the turnover, like customers in a restaurant, the body count, so to speak. And then also, could you explain to the audience, sir, just in brief, because the show's coming to a close, the influence and power of the corporations and how important it is to have lawyer representation, and how your rights to defend innocent victims is being suppressed by the power of the omnipotence of unlimited money from Wall Street. And thank goodness for lawyers. I'll just hang up and listen.
Well, thank you for your question, and thank you for calling. You raised some interesting questions, but I really couldn't comment on a lot of that. Number one, I don't have any specific firsthand knowledge of it, and it is a very broad question that addresses an issue that impacts society. I will address the question that you raised at the last, which I think is a very good point, and that is we do live in a complex society. There are very few things that people can do in any walk of life that is not impacted in some way by a law, a regulation, a contractual limitation, or some other legal ramification that affects their daily life. And so we do live in a complex society, and ignorance of the law is no defense, nor is it an excuse. And so everyone should, when confronted with some potential legal issue, consult with a lawyer. Not everybody needs a lawyer, but certainly the desirability of having a consultation with a lawyer in the particular area of law that you're facing, I think, is always advisable. Because if you go forward without that and you find yourself in a situation where you may be facing criminal or civil sanctions because of something you did that you did not appreciate the consequences of that, you're not going to have a very good defense that you were ignorant of the law or the application of the regulation or the statute. So we live in a complex society, and there are many, many laws and administrative regulations that affect all of our lives. And when that happens, the best way to deal with it is to find out if, in fact, you need to have counsel. Because, as the gentleman pointed out, big corporations have house attorneys that work full-time, and then they hire independent specialists to deal with environmental issues, contract issues, product liability issues, and so you certainly are not in a position to deal with those kind of things.
I don't know how you would answer this. I know we're at the very end, but you remember the story about the lady who was arrested for riding on a manatee? Her excuse was she didn't know it was against the law. So ignorance was her defense and her excuse. But how, if you were her attorney, since she was arrested, how would you use that ignorance?
I don't really think that, there's a Florida Wildlife Act that makes it an offense to interfere with or to touch or to interact with wildlife in their natural habitat, and that's a law. And if you are in fact doing that, it's like saying I did not know it was a 35-mile-an-hour speed zone when I was driving 55 miles an hour.
Well, except that it's posted.
I beg pardon?
Except, I don't mean to interrupt you, but it's posted on the road. It says 35 miles an hour. There was no sign on that beach that said no riding manatees.
Very good point. Even though a law may not be, quote, posted, the law says that every citizen is deemed to know the law.
Oh, wow.
And the fact that you may go dove hunting, and the limit for taking dove is 10. Some years it's 8, some years it's 10, some years it's 12. It's varied over my lifespan by a number of different ones. But when you get your hunting license and you go hunting, you're deemed to have read the law. And they give out brochures on that at where you get your license. Everybody is deemed to know the law. You are responsible for knowing the law. And if you don't, the ignorance of the law...
So you can't use that to defend her. You couldn't...
I wouldn't think that would be a very successful defense. No, I don't.
Well, she was in big trouble for that, too.
I suspect there are substantial fines for it. They're a highly protected species. I know if you're driving a boat in a no-wake zone and you're speeding through that, you can get you can be stopped and ticketed.
John, what is your phone number so we can get a hold of
Yes, our office at Fuller & Fuller is 352-547-4292. Our toll-free number is 855-534-2565. We have offices in Ocala and the Villages. If you're in an accident, if you have a commercial or business issue, or if you have Social Security disability where you aren't able to work and you have exhausted all other options and you think you might need a claim for Social Security, our office would be glad to set you an appointment.
And take care of all of that. And we enjoy listening to you. It's understandable why people come to you for legal help, John. Thank you.
It's a pleasure.
For what you do, and I'm glad you're back and had a good...
Thank you. It was very nice, and it's good to be back, and I thank our listeners who take the time to call in.
You're not kidding. We'll take a little break, and we will be right back.
Ocala's information station, 1370 WOCA.
Ocala.
ABC News Now. I'm Karen Chase. More women are taking the reins of the family finances. A new study finds 40% of working moms are primary or sole breadwinners of their households these days. That's up from just 11% in 1960. Food for thought to go with your breakfast cereal. Kellogg has